Gentleman from South Carolina is recognized.
Thank you, Mr. Chairman. Deputy Attorney General Cole, you have been done a tremendous disservice when the President prejudged this investigation. It's not fair to the people at the Department of Justice. It's not fair to the people who are investigating. It's not fair to the complaining witnesses, the potential victims. It's really unheard of for somebody who purports to be an expert in constitutional law to prejudge an investigation. So I'm going to start with that. And I know that you cannot provide names, and I know that you cannot provide details, but you have, on a number of different occasions this morning, sought to reaffirm that there is an ongoing investigation. So I'm going to ask you about some of the traditional investigatory tools and make sure that those are at play. And again, I'm not asking you for names, and I'm not asking you for specifics, but when you say a matter is being investigated, I think and by the way, back in the old days, you couldn't even confirm that there was an ongoing investigation. That was the policy back in the old days. I don't know if the policy has been waived or if this particular fact pattern is such that you are willing to confirm an ongoing investigation. But that's policy. That's not law. There's no law that prevents you from answering these questions. Have witnesses been brought before a grand jury?
As you well know, Representative Gowdy, we can't talk about anything that takes place before a grand jury. That's not permitted under Rule 6E.
Have subpoenas been issued?
That's also a grand jury matter.
Have administrative subpoenas been issued? Not grand jury subpoenas, but administrative subpoenas been issued?
With all due respect, Congressman, we don't talk about the steps we take in our investigations. They're thorough.
Mr. Deputy Attorney General, I understand that. But when the chief law enforcement officer for this country, the chief executive, prejudges an investigation, and you are seeking to assure us that that investigation is ongoing and vibrant and being professionally done, I think it is okay in this instance for you to reaffirm us that all the traditional tools available to prosecutors are being used. Administrative subpoenas aren't covered by Rule 6E, so you can answer that question.
We are using every tool that is appropriate to be used. We are using every facility we can to find out what the facts are in this matter as thoroughly and as completely as we can.
How many witnesses have been interviewed?
I cannot tell you that.
You cannot because you don't know, or you cannot because you choose not to answer the question?
It would be both.
More than 20?
I'm not going to go into a guessing game with you, Congressman.
Have any proffers been?
I'm not going to go into the details of the investigation. I'm sorry. I know that's frustrating, but when this is over, we will be providing you with details.
Well, how would we know when it's over? I mean, obviously, if there's an indictment, that it's over for that person until the prosecution, but how are we, look, you have a constitutional responsibility to do your job. With all due respect, so do we. It's different. Our job is not to prosecute criminal code violations, but it is our job to set policy and to determine whether or not an agency is worthy of the same level of appropriation that it received the year before. And we can't do our jobs if we are constantly told, not because of the law, but because of policy, that we're not going to answer any of the questions related to the investigation. So how will we know when this investigation is over?
We will let you know, either through an indictment that comes out, and you'll see that, or through us telling you that it's over and providing you with information.
You don't know how many witnesses have been interviewed?
I don't know an exact number, no, but I wouldn't tell you if I did, with all due respect.
Do you know what percentage of witnesses have been interviewed? Out of the full universe of witnesses that you have identified, how many have been interviewed?
I'm not going to go down that road, Congressman, sorry.
Have any plea agreements been signed?
I'm not going to go down that road.
Mr. Deputy Attorney General, I asked you the last time you were before a committee that I had the privilege of serving on, if you would please, in the quietness of your own conscience, consider whether or not this fact pattern is appropriate for a special prosecutor. And I'm sure that you did. But this morning you said you've reached the conclusion that it would not be appropriate. Can you give me the fact pattern where it would be appropriate? If prejudging an investigation that has political overtones and undertones, and the selection of, and I'm not prejudging Ms. Bosserman, she, I'm sure, is capable of doing a very fine job. I just find it stunning that she would be picked. Out of the full universe of available Federal prosecutors to pick a max-out donor, I just think was very short-sighted. So if it's not this fact pattern, what fact pattern would it be appropriate to ever use a special prosecutor, given the fact that your boss drafted the regulation?
It is very, very rare in the history of the Justice Department to use a special prosecutor.
Give me a fact pattern where it would trigger to you, in your mind, the appropriateness of a special prosecutor.
I can't go down and dream up a fact pattern, Mr. Gowdy, but I know the one time we have appointed a special counsel was in the Waco investigation, where Senator Danforth was appointed.
Well, the regulation is in place. It's pretty plainly written. The interest of justice, potential conflict. You have politics infecting this investigation. You have a prejudgment by the Commander-in-Chief that there's not a smidgen, and I'll substitute the word scintilla because smidgen is not a legal term. There's no evidence of wrongdoing. It's already been determined. You talk about jeopardizing investigation. You talk about compromising a jury pool. I mean, again, out of fairness to you, I'm not going to ask you to comment because he's your boss. But really, that was a tremendous disservice to be done to people who dedicate their lives to law enforcement, to prejudge an investigation, and to do it for a cheap political score during the Super Bowl. So, if not here, when? If not this fact pattern, when?
Each individual matter is going to have to be judged on its own individual and unique facts. I can't set out a prescription for when one would be appropriate. All I can tell you is we've analyzed this one, we've looked at the applicable regulations, and this does not meet any standard that would come to the point of warranting a special counsel.
When you say it's been analyzed, this is a determination that's ultimately made by the Attorney General himself?
Along with myself.
Did you seek outside opinions? Did you consult anyone else whose legal opinion you value and ask, hey, this is an interesting fact pattern. Maybe this is appropriate to go find a career prosecutor who hasn't maxed out to the RNC or the DNC? I mean, did you seek other people's opinions?
The internal deliberations, as you well know, Representative Gowdy, are not things we talk about in public, but we made a thorough review of this matter and determined it didn't meet any sort of standard to warrant a special counsel.
My time is up, Mr. Cole. I'm going to end the same way I ended last time. This is bigger than politics. It's bigger than election cycles. The one entity in our culture that is universally respected and represented by a woman wearing a blindfold.